Okay, try it again.
All right. The court is making a finding under the Ohio Supreme Court order dated April 22nd, 2020, under paragraph 5. That the proceeding is being held in person because of the court's needs, given the nature of the crime charged here, the possible consequences of that charge. This court has asked that Mr. Howell be present in the courtroom. He's complying with the order by wearing a mask. Mr. Dyckman elected to appear with his client. He is also complying with the order by wearing the mask, and are the only ones in the courtroom besides the bailiff and the clerk. We are set for sentencing today. Mr. Dyckman, are you ready to proceed?
Yes, sir.
And Mr. Rogers is the state?
Yes, Your Honor. Would you like me to come down to the courtroom?
Nope, you're fine.
Okay.
We are set for sentencing Mr. Howell. At the time of your arraignment on September 9th of 2019, you were informed that an information had been filed charging you in count 1 with abuse of a vulnerable adult, and in count 2, oh shoot, hang on, my system just moved on me. Count 2 of deaths to be reported to law enforcement officials and coroner. At that time, you're advised of the potential penalties involved, your constitutional rights, your plea options, and the effect of exercising each of those options. You then pled not guilty. However, on February 10th of 2020, you again appeared in court with your attorney, and pursuant to a plea agreement with the state, you withdrew your previous plea of not guilty and entered a plea of guilty to count 2 of deaths to be reported to law enforcement officials and coroner, and the state agreed to dismiss count 1 and to concur in the recommendation of the pre-sentence investigation. After you pled guilty, this should note first that that is a non-binding plea agreement, which means if I do not follow the recommendations of your attorney or the state's attorney, you would nevertheless not have the right to withdraw your guilty plea. After you pled guilty, this court ordered a pre-sentence report. That report has been furnished to the court, and I've reviewed it, and copies should have been furnished to your attorney and the state's attorney. Mr. Dyckman, did you receive a copy of that report?
I did, Your Honor.
And have you had an opportunity to review that with your client?
I have, if you want me to address that.
Go ahead.
He indicated that he really didn't have any disagreement with the PSI other than the findings and conclusions of the PSI investigator. It kind of goes to the fact that my sense of it, I'm reading that, it was the PSI investigator was angry at the mother and the father in the comments, but didn't really address the underlying disorders of my client. That is, he is autistic, he has a low IQ, that he suffers from some disabilities such as bipolar anxiety and depression. She kind of touched on that, but she didn't really touch on the fact that he has a low borderline range IQ. And the 2 different reports that I have, one said it was 74, one said it was 76. There's not really much difference in those. He's a special ed student his whole life. He has his autistic is such that he is they have what they call a developmental disability. It affects both his verbal and nonverbal communications. It affects his physical behaviors. He always tends to speak or talk in a flat or monotonous speech. The PSI investigator indicated that she didn't think he had showed any remorse because that's the way he speaks. It's part of his behaviors. He always talks in a flat or monotonous speech. He also has poor eye contact. inappropriate social interactions. He has problems in language comprehension. He tends to have poor avoidance of eye contact. He usually has some abnormal body posture or facial expressions on top of that. I mean, that's all part of his underlying condition. So I was kind of surprised that they were so, the PSI investigator was, my sense was angry, for lack of a better term. There was some discrepancy in the official version about whether or not he physically abused the grandmother. I can tell the court that my understanding of what he told me was that when he gave his statements to the police, because he did cooperate, that he felt he had to tell them what they wanted to hear because they kept repeating it and asking him over and over again. And finally, he told them what they wanted to hear. So I have some concerns about that. But other than that, there were no other changes to the PSI.
All right. Mr. Howell, have you had a chance to review that report with your attorney?
Yes, I have.
All right. Has the state received a copy of the report?
Yes, Your Honor.
Yes, Your Honor. I had my copy at the house. Just a minute.
Okay. You indicated, Mr. Howell, that you've looked at it, and that's all I asked you at that point. Mr. Rogers, you've received a copy?
Yes, Your Honor.
Are there any clarifications or corrections from the state?
Not from the state.
Mr. Dykeman, do you have any other clarifications or corrections?
No, sir.
Any objection to this court relying upon the contents of the report and fashioning a sentence? Mr. Dykeman?
No, sir. Other than just the court would consider my comments.
Okay. Mr. Rogers, any objection to this court relying upon the contents of the report?
No, Your Honor.
Are there any witnesses for the defendant?
No, Your Honor.
Any witnesses for the state?
Your Honor, we do have a niece of Miss Ware who is sitting in our conference room watching this by YouTube. She does not want to address the court. She just asked me to pass on some of her sentiments to the court. And therefore, we don't have any victims directly addressing the court today.
Okay. Mr. Dykeman, argument, sir?
Thank you, Your Honor. There was a book called The Sins of the Father by Jeffrey Archer. I don't want to get into the plot of the novel, but basically this story, or this should be the sins of the mother. The grandmother had a normal relationship with my client. She was displaying some behaviors consistent with her old age. She had some impaired mental ability. She was slightly malnourished, is my understanding. He found her body when he was age 19. She was deceased. He wanted to immediately call the police. The mother was with him. The mother told him no, and not to call the police. The mother told him she was afraid that she would get in trouble because the grandmother was malnourished, and she didn't want to report it. My client is easily manipulated. He generally wants other people's approval. He tends to do or says what other people tell him to do. Again, it's because of his low IQ and he's autistic. And so he went along with what she told him. He told her to move the body in several places. He did. And she eventually told him to bury it. He did. All the time, unbeknownst to my client and to everyone else, was the mother was keeping the Social Security benefits. And the mother was spending those Social Security benefits. She even told my client not to tell the father, which he didn't do because he respected his mother and wanted her approval and wanted to do what she wanted him to do. The mother was killed in an automobile accident, and this is how it all came to light. The family was trying to find the grandmother or the mother of the mother at that point in time, and they couldn't find her, and this is how this all came to light. Here's a young man. He's 25 years old now. When this first happened, when he first found the grandmother deceased, he was 19. He did what the mother told him to do. She was an authority figure. He wanted her approval, and he's easily manipulated by others, especially the mother, who's an authority figure, so he does what they tell him to do. He fully cooperated with the police. He showed them where she was buried. He told them what happened, how he found her. They did ask him numerous times if he ever abused her. He indicated to me that he did tell the police that he did abuse her, that he's kicked her and pushed her down on one occasion, but he felt compelled to do that because they kept asking him, and by they, I mean the police, and finally he told them what they wanted to hear. We have an agreement with the state. They would concur with the PSI. The PSI did recommend prison. I guess my concern of this is he's 25 years old now. He was shaken a few minutes ago. He has anxiety problems. When he did the PSI investigation, again, they kind of commented on this fact that he talks in a flat, monotone voice, but that's normal for someone who's autistic. He didn't show any emotion, but he's medicated, and it kind of keeps him calm, and he took his medication prior to going in, so it was a good dose, for lack of a better term. This is a case where I want the court to do justice. They list the Two-Hill decision. It's an 82 decision, I believe, and they talk about punishment, protection of society, and rehabilitation. Well, this is my client's first felony offense. He has no prior record. He was 19 years old when they found the grandmother deceased. He's 25 today. He has a low IQ, anywhere between 74 and 76. He's been a special ed student his entire life. He graduated, but again, it was with a special education degree. He has bipolar depression, anxiety. I think that given the variety of factors, the court has to consider that I think probation would be a fair sentence in this case. I think that if you tried to put him in prison, I don't think that would be meeting the factors of the Two-Hill decision, and I think that would be an abuse of discretion. If everything else, I told him there was a possibility this court could put him on retained jurisdiction, but I don't know how he'd do on that, based on his low IQ, based on his intellectual borderline disabilities, based on his his special needs he's autistic. I'm not sure how we do on a rider, so that's my concern. I think what would be the best course of action is putting him on probation. I think he would do well on probation. He complied with all the terms and conditions imposed on him when he was out and checked in regularly, not a problem, didn't miss anything. So I'd ask the court to consider that and consider the fact that of what I've just told the court about his physical health, his mental IQ, and his disabilities. Thank you, Judge.
Thank you. Mr. Rogers, state's recommendation.
Thank you, Your Honor. Before I get into my recommendations, just to pass on, Miss Nancy Gunter is in our conference room. She is the niece to Miss Ware. Miss Ware also has a sister in Pennsylvania, or a sister in West Virginia, and a brother in Pennsylvania, and they are older. Miss Gunter has expressed her feelings about this case, and the family collectively, I've been called from back east as well, and they feel that justice will only be served with a prison recommendation. I'm passing that on to the court. And now for my recommendations. First, before I get into those again, Mr. Dykeman and I sat down. This case invoked a lot of adjectives for me. The first of them being, this was a very unusual case, and Mr. Dykeman was, I think we both were in new territory, and we tried hard to resolve this case, and it was a very positive experience working with him, and just to pass that on to Mr. Dykeman. Now, to go through just this case and dealing with this case and how it has influenced Bingham County and our sheriff's office, and I know the lead detective on this was very concerned about this case. Going through it and reviewing it, there is nothing short that I can describe this with than either bone chilling or eerie. Every day from the beginning of the search warrant, there was something new that was just something I had never dealt with before, something very eye-opening, and something very eerie about it. There are still many suspicions in my mind about the overall what happened. Given count 2 of what Mr. Howell has pleaded guilty to, I do not believe that we can place all of the blame on Danielle, his mother. So even if we were to consider all of what the defense has been in this case and the argument we heard today, we can take away that Mr. Howell understands, or he understood what he was doing, because he was attempting to protect his mother in hiding Miss Ware's body. He understands what abuse is, given the PSI, because he describes abuse, or he gives us a definition of hitting and kicking. So he understands right from wrong. And he understands that what he did in this case was wrong. The best description, or my voice was best represented in this last paragraph on page 15 of the PSI. And whether or not the PSI writer put emotion into this or not matters not to me, because this last part describes what I think about this case. The abuse Miss Ware apparently suffered while living with Mr. Howell and his mother was horrendous by any reasonable standard of decency. Equally disturbing is the fact that Mr. Howell and his mother allowed Mrs. Ware to become extremely malnourished. The manner in which Mrs. Ware's corpse was treated following her death is repugnant and contrary to the mores, I think it's supposed to be morals, and value of any civilized society. Mr. Howell would not give investigators a correct timeline of the events. He and his mother kept the knowledge of their crime a secret. They lied to family and friends for over 4 years about what had actually happened to Miss Ware. The way they concealed Miss Ware's corpse show they had mental capacity to be aware of their mistreatment. The only correction I would make in that is that Mr. Howell will not give investigators a correct timeline of the events. I believe that he tried the best he could to give a correct value of the timeline of events. Other than that, that describes why this case has been bone-chilling and eerie from the very beginning. And with that, Your Honor, we talked, Mr. Dykeman spoke of the two-hill, and I know the sentencing criteria, we talk about deterrence and rehabilitation, but here we need to talk about value and why we have, and the policy behind the statutes. There needs to be a reported death for this very reason, so the deceased cannot be taken advantage of by people, which there's still some suspicion out there, and I won't go into details about that since it's not part of this case. But just know that that's lingering out there. Here we have Mr. Howell and his hands moving the body several times so that other individuals will not become aware and his mother would not get in trouble. For that, Your Honor, I would ask the court to follow the recommendations of the pre-sentence investigation And my recommendation would be 7 years and 3 years of indeterminate for a total of 10 years to be served in the Idaho Department of Corrections. Thank you, Your Honor.
Thank you. Mr. Rogers, I do have a question or two for you. So he's been charged with failing to report or notify the coroner or law enforcement of a death and failure to take reasonable precautions to preserve the body and so forth. When you get into that paragraph that you talked about, and I think this kind of goes to Mr. Dykeman's argument, is he's not been convicted of abuse or exploitation of a vulnerable adult. And so there may be these arguments or things about kicking or hitting the victim in this case, but that's not really, doesn't really go to the charge that he has been convicted of. And here's the other thing that I have a question. In that last paragraph, equally disturbing is the fact that Mr. Howell and his mother allowed Ms. Ware to become extremely malnourished. Number one, I don't know that we have evidence of malnourishment. There's some discussion about that and concern about that. But the second thing I have a question about is what evidence or how do we know that that was even Mr. Howell's responsibility? And so I think it goes to the emotional part that Mr. Dykeman's talking about. We have to focus on, and I think you've done that to the most extent, but there are these issues I want to make sure that we separate what he's pled to and what really goes to that. So if you'll address that issue.
So first of all, Your Honor, talking about the abuse and the hitting and kicking, perhaps I'm thinking quicker than I can talk, but I did not mean for that to go towards the argument of punishment. I only meant for that to go towards the argument of his intelligence and how he understands what's going on. He is able to give us definitions of terms in a deep sense. And that is what whether it was abuse or mowing the lawn, whatever it might be, he is able to give us definitions in a deep sense of what he thinks it means. The one example that we have is they were talking about abuse, and he defined that as hitting and kicking. I am not asking the court to take that under consideration as to what he has pled guilty to, except for the fact of he is able to define terms, and he is not, in my mind, as innocently minded as it might be made out to be. The number two thing, you addressed mistreating Miss Ware's corpse, or Miss Ware as a person.
The malnourishment in second paragraph or second sentence of that last little paragraph on page 15.
Perhaps the best. So I am not meaning to go anywhere outside of count 2, and that certainly does. So strike my argument for that outside of off the record. I strictly am trying to argue him hiding the body for so many years in so many ways constitute a drastic measure that the court needs to be taking. Has nothing to do with the malnourishment or abuse of his grandmother at this point.
All right.
Does that answer your questions, Judge?
It does.
Okay.
Mr. Howell, do you wish to make a statement on your own behalf?
Yes, Your Honor.
Go ahead.
When I was 19, I found my grandmother lying on the ground. She passed away. I wanted to tell authorities on exactly what happened, but my mom persuaded me not to because of the fact we would get in trouble for it. I do exactly what my mom says. She's my caregiver. I can't, other people make decisions for me at that time and age. I have a hard time thinking for myself. I just do what my parents and or friends do. So I did. She persuaded me not to tell authorities on what happened and to basically hide the fact that my grandmother passed away from everybody. So she suggested to bury her at the end. So I did. It was all just, she just told me to, and I did.
Anything else? Sir?
I'm deeply remorseful for what I did. I never wanted any of this to happen. I wanted authorities to know what happened. That was my first instinct. I got told not to. The situation that happened. I deeply am remorseful. I'm deeply sorry for what happened. I never wanted any of this to happen.
You knew what your mother was asking to do was wrong, though, right?
In a sense, she persuaded me that nobody would find out and it would be okay. So I just went with the plan. I don't know a better way of saying that. I didn't know. I got stuck in a position where I basically shut down inside because I didn't know how to handle it because my grandmother passed away and I didn't know what to do. I wanted to call authorities, but I got forced into not calling authorities and to hiding it.
Let me ask you this. Why did you want to call the police?
Because I wanted to call the police because my grandmother passed away. I wanted it, people should know that somebody has passed away, I believe.
That was the right thing to do, right?
I am, in a sense, yes, I wanted it to be taken care of like that. I got forced into it not being taken care of like that instead. Your Honor.
Could I address one of the issues you brought up, Your Honor, or what actually the state brought up?
Go ahead.
They talked about the timeline. Well, part of his autistic disability is time and sequence of events. If you look at it, because he's developed disability and his lack of communication skills and stuff, he has a hard time, and it goes to again his autism of explaining time and events and stuff. So I just wanted to address that issue. I think I've covered everything else. My concern is, again, is they're taking a broad brush from the sins of the mother, for lack of a better term, and they want to punish my client.
Let me ask you this. When you go through and you look at the objectives of criminal punishment adopted under Hill, you look at the facts of this case, and in particular the facts as they apply to count 2, that he moved this body several times, never reported it, and it didn't come to light until after the police show up at his door. I go through that, and even talking to your client, he has the sense of right and wrong and knew that what the right thing was to do, but he complied with his mother's demands. And that's where this gets kind of tricky, because I don't have any expert in here to tell me how his autism, his low functionality, I can guess that he is probably easily manipulated, especially by a close relative and a mother. But I'm struggling a little bit with, there needs to be some punishment in this regard, and how do we obtain justice with an individual who's committed a crime like this, but also has the intellectual deficiencies and the disability of autism, for lack of a better word.
And the low IQ.
Right. So,
and I have the same concern.
How do I deal with that when I don't have an expert here to say, hey, here's what is going on with his life. Here's what will happen if you do probation. Here's what will happen if you do retained jurisdiction, or here's a likely outcome if you put him in prison. Because quite frankly, I think that something fairly severe has to be done here outside of probation, but at the same time, I'm cognizant and I'm a little bit worried about what will happen if he just goes to prison and what will happen if he does retain jurisdiction. Are we going to make this individual worse? Are we going to make him better? And I don't know that I have answers to that right now because I don't have an expert to give me those answers.
If I may, the only reports I have are the ones that were supplied to me. There was first there was a report, I think, by Dr. Christensen about his mental capacity. Then there was 2 other reports about his low IQ and that he was autistic. I relied on those reports, and I supplied those reports, or the court should have those reports. So I have the same concerns. I'll be honest with you, Your Honor. I'm not diminishing what happened. I think it was atrocious, but at the same time, I feel like my client was manipulated. He does what people tell him to do because of his disabilities, because of his low IQ, because he's autistic, and because he has a low functioning social, he's not normal. He doesn't have normal behaviors, Your Honor, and not by any stretch. And he's never had them, and he probably never will. So that's why my recommendation is put him on probation, let him see how he does. I think he'll do well. I mean, again, it's his first felony offense, no prior offenses. And I'm not diminishing the crime. I'm just saying it is what it is, and he is what he is.
How much time's he done in jail?
I don't know that off the top of my head.
Oh, he did 1 day.
I think he did at least 1 or maybe 2 days.
2 days.
All right. Mr. Rogers, do you have any response to my questions or concerns?
I have some thoughts about things, Your Honor. I know I have already made my argument. To respond to what you're asking for, I think under the same thought process, we would also be able to counteract any expert by putting on numerous family members to probably show that he was decisive and that he can make decisions. And we're talking about this happening at the beginning. He reported in 2014 on page 6 of the PSI. It mentioned something about, let me turn to it. The very beginning paragraph of page 6 of the PSI, we thought we were all going to jail. So from 2014 until now, there's been no punishment. There's been no repercussions for what he did on hiding the body. And I think the court should also take that into consideration, not just with intellect. I mean, even today he's talking about, he knows right from wrong. He knows this was wrong, and he knows the consequences were jail. And it's got to meet the value of the crime to me. And so we would ask for an imposition of a sentence, Your Honor.
Right. Mr. Howell, based upon your plea of guilty as a judgment of the court, you are guilty of count 2, deaths to be reported to law enforcement officials and coroner. When I sentence an individual, I have to consider the objectives of criminal punishment adopted by the Idaho Supreme Court, which includes protection of society, deterrence, rehabilitation, and punishment. I also have to consider the factors under Idaho Code 1925-21 relative to the question of whether I should place you on probation or confine you to prison. We go back and look at the PSI. You're 25 years of age at this point. You were 19 when this occurred. This is your first felony offense. Your LSI score is a 27, which puts you in the moderate risk category. There's no substance abuse issues. There are some mental health issues, PTSD, generalized anxiety, major depressive disorder, and bipolar. You're low functioning, you have ADHD, and you have autism. The pre-sentence report recommends prison. Your attorney has asked for probation and the state has asked for prison. What it really comes down to is whether you knew, what it comes down to me, I think, is whether you knew that this was right or wrong, and I think you knew that this was wrong. But I also believe that you had a mother who was able to manipulate you, but that doesn't negate the duties and obligations that you have as a citizen of our community and as of your age. You go through the PSI. And in particular, when you go to your version, you indicate that you found her dead, your grandmother. You indicate that your mom panicked. You knew what that meant, and that she was concerned that she'd be in trouble because of the living conditions. And you wanted to say something, but you were forced not to. So you hid it from everybody. In the second paragraph on page 6, when asked how you felt about it, you commented that it is bad what you did, but not as bad as everyone makes it out to be. It was an unavoidable mistake. But you know just the opposite is true. And it was a mistake, but it was not unavoidable. You could have corrected that immediately by not listening to your mother. Or at least down the road, you could have even made and come forward by talking to somebody else in the family or to law enforcement. I don't put a whole lot on the emotion part. I am familiar with autism and how that displays differently in individuals affected by that. But I've watched your demeanor here today, and you've seen some of that emotion as well. You indicated that you committed the offense because you were scared. You graduated from high school, and I know that you graduated even though you have some intellectual functional issues. You're being treated for the ADHD, autism, anxiety, PTSD, major depressive and bipolar disorder. And like Mr. Rogers indicated, I think that last paragraph with some limitations really kind of puts the case in perspective, because the manner that Miss Ware's body was handled after the death really is repugnant and contrary to the mores and values of a civilized society. And I think, Mr. Howell, that you have the capacity to understand that, and you do, simply based upon your own statements. And to simply say, we're going to put somebody on probation, even though it's the first felony offense, just flies in the face of justice, even given the mitigating factors of your case. Therefore, based upon all the circumstances, it will be the judgment of the court that you be sentenced to the Department of Corrections for a fixed and determinate period of 3 years, an indeterminate period of 7 years, in other words, not less than 3, no more than 10. You're fined the amount of $1,200. Court costs are $245.50. You'll be required to provide a DNA sample and thumbprint to the state and cover the costs associated therewith. My real debate that I have, Mr. Howell, on this is whether I ought to do retain jurisdiction or simply impose the sentence. And it's not an easy decision to make. And that's why I'm hesitating a little bit. I think under the circumstances, I'm going to retain jurisdiction for up to 365 days. I simply want to see how you do. And whether any progress can be made in rehabilitative efforts, and whether the change in thinking can occur. It's not a guarantee that you'll get probation, even if they recommend probation. I need to see how you're going to do and how you're going to perform. And therefore, the court will retain jurisdiction for up to 365 days. You understand the sentence, sir?
Your Honor, I don't know what retraining really is.
So,
what is that?
Okay. What that means is you're going to go to prison for up to a year. You're going to be in a program. They'll determine which programs are best suited for you. If you do well and make progress in treatment, and as long as you follow the rules, they will send the Department of Corrections will send a letter to me recommending that I place you on probation. When I look at that and look at your performance, and I look at their recommendation, if I determine that it's appropriate, then I can bring you back and put you on probation. If I don't think it's appropriate, I can simply relinquish jurisdiction, which would mean to impose a sentence and you would do your time. At the same level, if you don't make any progress and you violate the rules, they'll send me a letter saying I should impose a sentence, and I'll have to review that and make a determination on whether that's the correct thing to do or not. So it's kind of a testing ground for you to determine whether or not you can be successful on probation and be monitored in that fashion. You understand that?
Yes, Your Honor.
All right. Now, Mr. Howell, you have the right to appeal this decision. That appeal has to be filed within 42 days. You have the right to be represented by an attorney on that appeal. If Mr. Dykeman cannot represent you on any appeal, you can ask the court to have counsel appointed to represent you on that appeal. You just have to remember you only have 42 days in which to file the appeal. Do you understand that?
Yes, Your Honor.
All right. You may also have the right to seek relief under Idaho Criminal Rule 35. That's a mechanism where you can ask this court to reconsider its sentence. That has to be filed within 120 days after entry of the judgment against you. Do you understand that?
Your Honor.
You may also have the right to seek relief under what's called the Idaho Uniform Post-Conviction Relief Act. That is a civil action that you would file separately from the criminal case. And you can allege certain errors in proceedings in the criminal case. If you elect to do that, that has to be filed within 1 year from the date your appellate time expires. That means if you do not file an appeal, you have 1 year and 42 days to file that civil action. If you do file an appeal, you have a year after the appellate decision is made to file that civil action. Do you understand that time frame?
Yes, Your Honor.
All right. If you have questions about how or whether to proceed with any of those rights, you can discuss those matters with Mr. Dykeman and he can advise you. If for some reason he cannot advise you, you can apply to the court to have counsel appointed for that purpose. Do you understand that?
No, not really. I really don't.
So if Mr. Dykeman can't represent you any further in this case and give you any more advice, you can ask to have counsel appointed. Do you understand that?
Not, I still really don't get that. Sorry.
Okay, so you still have some legal recourse that you can take that I've just discussed with you. Mr. Dykeman's your attorney, right?
Yes, he is.
And he's given you advice throughout this case, correct?
Yes.
If he can't give you any legal advice anymore and is not going to represent you anymore, and you can't afford an attorney of your own, you can ask the court to appoint an attorney to represent you from this point on. Do you understand that?
I do.
All right. At this time, then, you're remanded to the custody of the Bingham County Sheriff's Office to be transported to the proper agent authority for purposes of serving in the retained jurisdiction program. Mr. Dykeman, do you have anything else today, sir?
No, sir.
Mr. Rogers?
No, Your Honor.
All right. Mr. Dykeman, you're excused.
Thank you, Judge.
Thank you.
You gotta go with those guys. All right, I'll be in touch. Yep. Thank you, Judge.
Thank you.